Hello, Namaskar, good evening. This is Balneet Singh Bedi. I welcome all of you to the daily news analysis session by Tathastu ICS. Good evening, Lavanya, Mansa, Yogita, Rudra. Good evening, everyone. Utkarsh. Let's start today's session. So, under Mains Manthan, we have two important news. The first one is CJI assures complete transparency in the collegium system. Now here we will be discussing, it's on page number 9 of Delhi edition, The Hindu. So we will be covering the collegium system in detail. What is collegium system? What about the three judges case? The first, the second, the third. What are the challenges they are facing? Who heads the collegium system? All of that we will be covering in detail, and that is also very important from your exam perspective. I'm really good, Kunal, thank you. Good evening, Deepika, Shiv, Karan, Khan Bhai, good evening, everyone. Then comes the next one, a deliberate strategy to usher in a communal order. Now this editorial we have discussed yesterday as well. You remember what we have discussed yesterday? We have discussed about the words socialist, about the word secular. Now there are few political groups, that is RSS as well as the Vice President of India, asking to remove these words from the preamble as they were not originally mentioned in the preamble of the Indian Constitution. But the editorial is saying that by removing these words, you are creating communal problems in India. And though these words were not mentioned in the Constitution earlier, or when it came into force on 26th of January 1950, but if you talk about the core principles, the core tenets, the foundational philosophy of the Constitution, all these words, though not mentioned, but have its essence, have its roots in fundamental rights, in DPSPs, and fundamental duties, and also in many other parts of the Indian Constitution. So it is saying, please do not remove these words. And the author has explained so many views of Mahatma Gandhi, Begum Abdul Aziz, then Sardar Vallabhbhai Patel, B.R. Ambedkar. All of the views have been shared, and that is the reason I'm sharing it with you here as well. Good evening, Dheeraj, Sneha, Karan Avasthi, Jigar, Sena, Sajal, Sonali, Ayana. Good evening, everyone. Now let's focus here. Then under prelim Sarthi, we will be covering Nipah virus. Now Nipah virus is getting lot more famous, and the cases are coming again in the state of Kerala. Okay, so I hope I have given you a gist of all the editorials which we are going to discuss in the upcoming session. Good evening, Rishi. Then comes the number one, that is CJI, that is Chief Justice of India. And who is Chief Justice of India? That is Bhushan Kumar Gavai, right? This is the picture of Bhushan Kumar Gavai. Why in news? Again, see, now this news, if you just look at from the perspective of news, it's not relevant from the UPSC, पर जो इसका context है, and that context is nothing but collegium system, right? This is important from our exam perspective, and that is why I have included here, as well as it covers the GS paper 2 Indian polity. Okay, then the first thing comes collegium system. Now what is collegium system? Anyone? What is collegium system? Anyone can tell me? What is collegium system? You must have heard about it. So basically, collegium system is a system of the appointment as well as transfer of the judges, which has evolved through various judgments of the Supreme Court. And this collegium system is nowhere mentioned in the Constitution of India or in the provisions of the Constitution or any of the act framed by the Parliament of India. So basically collegium system एक ऐसा system है जिस system द्वारा जजेस को अपॉइंट किया जाता है, जजेस को ट्रांसफर किया जाता है, और ये सिस्टम एक ऐसा सिस्टम है जो सुप्रीम कोर्ट के जजमेंट से इवॉल्व हुआ है, ना कि ये किसी संविधान में मेंशन्ड है और ना ही हमारे किसी एक्ट जो पार्लियामेंट बनाता है उसमें मेंशन्ड है. सो दिस सिस्टम हैज इवॉल्व थ्रू वेरियस जजमेंट्स ऑफ द सुप्रीम कोर्ट ऑफ इंडिया. यस खान भाई, वेरी गुड, very good. So this is collegium system. Okay, again it's very important from your exam perspective as well. Then comes the evolution of the collegium system. Now what comes under evolution of collegium system? Now the first judge case that happened in the year 1981. अब जो पहला जज केस था 1981 का, वो क्या कहता था? उसने कहा कि भाई जो सीजेआई दैट इज चीफ जस्टिस ऑफ इंडिया जो भी रिकमेंडेशन देगा, जो भी अपॉइंटमेंट के लिए एक डॉक शेयर करेगा लॉ मिनिस्टर के साथ, वो प्राइम मिनिस्टर को शेयर करेंगे. देन प्राइम मिनिस्टर विल एडवाइज द प्रेसिडेंट. सो इस डॉक में एग्जीक्यूटिव का भी ओवर हैंड है, मतलब एग्जीक्यूटिव का भी एक बड़ा रोल है, जो सरकार है उसका भी बहुत बड़ा रोल है. और वो जो सीजीआई ने अपनी ओपिनियन दी कि भाई इस इंसान को आप अपॉइंट करो एज अ जज ऑफ द सुप्रीम कोर्ट, सो एग्जीक्यूटिव or the sarkar can reject that name, can avoid and can say that due to some these reasons we do not want to appoint this person as a judge. So पहले जज केस में सरकार को भी एक अपर हैंड दिया गया था, एग्जीक्यूटिव को भी एक बड़ा रोल दिया गया था in the appointment of the judges. But then comes the second judge case that is in the year 1993. तो ये सिस्टम कम से कम 12 साल तक चला, राइट, 1981 से लेके 1993 तक. उसके बाद 1993 में हमारा सेकंड जज केस आया. इस केस में क्या सिस्टम आया? इस केस में आया कोलेजियम सिस्टम. नाउ दिस जज केस इंट्रोड्यूस द कोलेजियम सिस्टम एंड इट सेड कि भाई जो सीजीआई की ओपिनियन है जो वो पहले जज केस में दे रहा था, वो सिर्फ सेकंड जज केस में कहा गया कि वो ओपिनियन सिर्फ एक सीजेआई की नहीं है, वो चीफ जस्टिस ऑफ इंडिया की नहीं है, बल्कि वो चीफ जस्टिस ऑफ इंडिया के साथ साथ दो सुप्रीम कोर्ट के सीनियर जजेस की भी है, राइट. सो इट्स नॉट द सोल ओपिनियन ऑफ द चीफ जस्टिस ऑफ इंडिया, रादर इट इज द ओपिनियन ऑफ सीजेआई प्लस 2 सुप्रीम कोर्ट सीनियर जजेस एज well. Khan bhai, CJI is Chief Justice of India, Supreme Court is an independent body. Okay, Sneha, I'll repeat, listen to me very very carefully. Sneha, in first judge case it has said कि जो भी CJI अपनी opinion देगा in order for the appointment of judges, उसके बाद executive का, law minister का या सरकार का, prime minister का इसमें एक upper hand होगा और वो एग्जीक्यूटिव सीजीआई की ओपिनियन को रद्द भी कर सकता है, इग्नोर भी कर सकता है ड्यू टू वेरियस रीजंस. बट सेकंड जज केस ने कहा, इस केस ने कोलेजियम सिस्टम को बर्थ दिया और कहा कि कंसल्टेशन मींस नॉट ओनली कॉन्करेंस. देन इट आल्सो सेड कि सिर्फ एक सीजीआई की ओपिनियन नहीं है, इट्स नॉट द सोल ओपिनियन ऑफ द चीफ जस्टिस ऑफ इंडिया, बट रादर also the 2 senior judges of the Supreme Court. So I'll just quickly repeat it for you. It declared that the primacy of CJI recommendation on judicial appointment can be refused for cogent reasons, and then the ruling gave the executive primacy over the judiciary in judicial appointments for the next 12 years. Then comes the second judge case in the year 1993. Here it said it introduced the collegium system, holding consultation really meant concurrence. It was not the CJI individual opinion but an institutional opinion formed in consultation with 2 senior most judges in the Supreme Court. उसके बाद हमारा आता है थर्ड जज केस दैट इज इन द ईयर 1998. अब इसमें अंडर आर्टिकल 143 प्रेसिडेंट ने अपना रेफरेंस दिया और प्रेसिडेंट ने सुप्रीम कोर्ट को कहा कि सिर्फ सीजीआई और 2 जजेस नहीं, आप इस बॉडी को 5 मेंबर बॉडी बनाओ. इसमें आप पहले तो सीजीआई प्लस 2 जजेस थे, अब हमारे पास सीजेआई प्लस 4 सीनियर मोस्ट जजेस ऑफ द Supreme Court. 4 senior most judges of the Supreme Court would be there, right? So this has been said by the Supreme Court in the third judge case, that is in the year 1998. I hope I'm making this clear to each one of you. I've tried to simplify it at the very easiest level as well. Then comes SC on the precedent reference. Article 143 expanded the collegium to a 5-member body, CGI plus 4 of his senior most colleagues. Then comes who heads the collegium system. अब देखो, अगर SC collegium है, that is Supreme Court का collegium है, तो वो कौन head करेगा बच्चे, आप बताओ. It will be headed by B.R. Gavai or the present incumbent CJI, that is Chief Justice of India would be heading that, and it also comprise 4 senior most judges of the Supreme Court. Okay, और अगर High Court का collegium है तो वो कौन head करेगा? The CJ, the Chief Justice of High Court. So it will be headed by Chief Justice of High Court and 2 senior most judges of the High Court. So this is the High Court collegium and this is the Supreme Court collegium. Now if you will read, it is headed by Chief Justice of India, 4 other senior most judges, High Court collegium, that is incumbent Chief Justice and 2 senior most judges of that High Court. Then lastly comes judges of the higher judiciary are appointed only through the collegium system and government has a role only after names have been decided by the collegium. Then comes the procedure for judicial appointment. अब CJI को कौन appoint करता है? So basically बच्चे, in 1970s there was a controversy during the appointment of the CJI. अब सरकार क्या करती थी, जो भी जज उनके फेवर में जजमेंट्स देता था, उनके फेवर में काम करता था, वन मिनट बेटा, अंकित आप इसको ब्लॉक कर दीजिए, हर्षवर्धन को. If you are making all these sort of comments here, I'll be forced to block you, right? So make sure, keep this as an academic channel and academic comments would be welcome. Even if you're gonna ask 10 questions, I'm there to answer. But if you are writing all these shairis for some other colleague who are watching, this is just not acceptable to me as well as to the institutional dignity. So please take care of it in future, Harshvardhan. Otherwise, I'll be forced to block you. Then procedures for judicial appointments. The first one comes for CJI. तो 1970s में जो भी जज सरकार के हित में फैसला सुनाता था, उसको कहा जाता था कि सीनियरिटी लेवल को इग्नोर करते हुए आपको चीफ जस्टिस ऑफ इंडिया बना दिया जाएगा. बट नाउ द सिचुएशन इज, जो भी करंट सीजेआई, नाउ प्रेजेंटली, अर्लियर इट वाज डीवाई चंद्रचूड. So before he leaves the office, he recommends the appointment of the next CGI based on seniority. जब डीवाई चंद्रचूड के बाद जो भी सबसे सीनियर मेंबर है, सीनियर जज है सुप्रीम कोर्ट का, that will be appointed as the CJI, that is Chief Justice of India. So for CJI, this is the process. Then comes for the Supreme Court judges. As I've said, the collegium, that is CJI plus 4 judges of the Supreme Court. 4 judges of the Supreme Court, they sit together and they consult the name of the High Court judges कि भाई ये High Court में अभी काम कर रहे हैं, अब इनको elevate करके हमें Supreme Court में लेके आना है. तो ये decision they forward it to law minister. Then law minister forwards it to Narendra Modi. Then Narendra Modi forwards it to President of India, that is Draupadi Murmu, right? So this is the process. They take a decision, they forward it to law minister forward it to prime minister, then prime minister forward it to president, and ultimately it is the president who will appoint the judges of the Supreme Court as well as the High Court. Then comes for Chief Justice of the High Court. Again, this is the same scenario. जो भी current working CJ होगा High Court का, along with two senior judges of the High Court, they sit together, they recommend the name of the upcoming CJ of High Court, and then they give the name to the Chief Minister. Then Chief Minister forwards it to the Governor of the state, and then Governor forwards it to the Law Minister of India or the Union Law Minister. Okay, so Chief Minister, then Chief Minister to Governor, then Governor to the Law Minister. So this is the procedure for the judicial appointment for CJI, for Supreme Court judges as well as the Chief Justice of the High Court. Good evening Roshni, good evening Praveen as well. Then comes the next. अब ये सब प्रोसेस के इश्यूज क्या हैं, challenges क्या हैं? First thing is exclusion of executive. अब एग्जीक्यूटिव का तो रोल कम हो गया भाई, सीजे अपने कोलेजियम के साथ बैठा, उसने अपने जजेस का नाम दिया, अब सरकार के पास ज्यादा कोई चांसेस नहीं है नाम रिजेक्ट करने के, नाम कुछ करने के, उनको नाम को पास ही करना पड़ेगा. सो एग्जीक्यूटिव का क्या हो गया, एग्जीक्यूटिव की प्रॉब्लम कम हो गई. नो ऋषि, Attorney General is different. That is the highest law officer of India. He is the law minister. There is a difference between law minister and the Attorney General. And I can't recall who is the present law minister. I guess it's Kiran Rijiju. Maybe or Arjun Ram Meghwal. Arjun Ram Meghwal could be the law minister. So law minister is different and Attorney General is totally different. Okay. Attorney General is the one who represents the cases of the government of India in the Supreme Court as well as the High Court. Law minister is altogether a different personality. He is a minister and the another one is a officer. Then comes the chances of favoritism and nepotism. अब जो collegium system है, might be they prefer someone who is from their family or extended family. So they prefer favoritism, they prefer nepotism because there is no transparency, there is no clarity in the appointment process, and all this is happening behind the closed door. So it's against the principles of checks and balances. Now what does this mean? जो भी हमारा संविधान कहता है, the legislature, the executive, the judiciary, these are three separate organs and they three are working separately in their own field, in their own arena. So against the principle of the checks and balances. अब judiciary के ऊपर check रखने का तो सवाल ही नहीं रह गया. जो वो recommendation कर रहे हैं वो law minister prime minister को, prime minister president को भेज रहा है. So it's against the principle of checks and balances. As I've just mentioned, closed door mechanism. It's something which is happening behind the closed door and that would be a problem as well. Then last come unequal representation. If you talk about women, so women have very low representation in the Supreme Court. Now only judge which has representation, it is B.V. Nagaratna. B.V. Nagaratna. Earlier there was Bela Trivedi, but recently she got retired from the Supreme Court. So it is B.V. Nagaratna who is the sole women Supreme Court judge. Then comes the attempt. What are the attempts to reform the appointment system? So हमारी सरकार ने क्या किया था? 2014 में they brought National Judicial Appointment Commission. National Judicial Appointment Commission they brought, through which Amendment Act? 99th Constitutional Amendment Act 2014. But Supreme Court declared this as null and void. It said that it is threatening the independence of the judiciary and there is too much executive interference. So it has struck down and declared it as null and void. Okay, so this much only is important from this perspective. Then comes the next, that is the prelims PYQ. Now quickly solve this question, everyone. Quickly solve the question. Okay, so here we will quickly discuss the question now. Now the first statement says, while appointing the Supreme Court judges, the President of India has to consult the Chief Justice of India. This is a right statement. Then comes, the Supreme Court judges can be removed by Chief Justice of India only. This is a wrong statement. They can be removed by President. And if you remember, we discussed yesterday the process of removal of the judges. Okay, Utkarsh, Mansa, Yogita, Izhar, Sujata, Deepika, Roshni, correct answer. Okay, correct answer. So Chief Justice of India cannot do that. Then the salaries are charged on the Consolidated Fund of India, to which legislature does not have to vote. This is a correct statement. Then comes, all appointments of office, this are made by the government only. बेटा absolutely wrong. जितने भी officers हैं, जितना भी staff है सुप्रीम कोर्ट ऑफ इंडिया का, वो कौन अपॉइंट करेगा? वो CJI, that is Chief Justice of India, will appoint. So this is wrong. Second is wrong. The correct is 1 and 3, that is A. A is the correct answer. Very good, Utkarsh. Roshni, you have given the correct answer here. Very good, Khan bhai. Second and fourth statements are wrong. Then comes the next question asked in the year 2014. Quickly tell me. Amrita, you can drop down your comment below the video, and our team will definitely get back to you with all the relevant details of the courses you wish to join at Tathastu ICS. Good, Hina. Good, Chandra Prasad. Come on, more answers I'm expecting. Quickly, everyone. Good, Ekta, Dheeraj, Dinesh, Piyush, Deepika, Sonali, Rishi, Shaboni, Sabu. Very good, very good. Everyone has given the correct answer. Yogita, Khan Bhai, Shaboni, everyone has given the correct answer. Here the correct answer is Parliament of India. So only Parliament of India has the power to increase the number of judges in the Supreme Court of India. Then we will move to the next question. So here the correct answer is B. Okay. Then comes the next one. Solve this question. Quickly tell me the answer, everyone. Good Khan Bhai, Sujata, Chandra Prasad, Ekta, Yogita, Kathiravan, Khan Bhai, Mansa, Sneha, Shramoni. Good, good. So the first statement says any retired judge of the Supreme Court can be called back to sit and act as a Supreme Court judge by the Chief Justice of India with the prior permission of the President of India. This is a correct statement. Then comes the next. A High Court in India has the power to review its own judgment as the Supreme Court does. This statement is wrong. This statement is wrong. हाई कोर्ट के पास पावर तो है, but it does not have exclusive power to review its own judgment, whereas Supreme Court has the power to review its judgment. So the correct answer here is A, that is one only. Okay, then I have one more question for you. Quickly solve this question, everyone. Very easy one. Jai Hind Sabu, quickly give me the answer. Good, Ekta. Revise them as well and do the proper analysis of all the PYQs. Hina is saying D, Khan Bhai is saying D. Very good. Rishi, Khan Bhai, Dheeraj, Sneha, all of you have given the correct answer. That is D. The Supreme Court of India is the custodian of the Samvidhan of India. That is Bharat ka Samvidhan, and the custodian is Supreme Court of India. Very good. You have solved 4 PYQs and all of them are important related to the collegium system. If not collegium system directly, then definitely the Supreme Court as well as the High Court. Good, Deepika, Ekta, Anish, Sonali, Mansa, Chandra, Shraboni. Very good. Then comes the next one. See, this editorial we have discussed yesterday as well. So today I'll be quickly doing this with whatever examples needed I will try to give you. So let's focus here, Khan Bhai. A deliberate strategy to usher in a communal order. Now there is a demand to remove 2 words, that is socialism and secularism, to be removed from the constitution. As I've explained, it's a demand from various political groups, that is RSS as well as the Vice President of India as well. Then the second, it covers GS paper 2, Indian polity. Then comes the first one, SC upholds secular and socialist in the preamble. So if you read on the 75th anniversary, Supreme Court has dismissed the petition challenging the inclusion of secular as well as the word socialist in the preamble. It has stated that absence of these terms, okay, 42nd Amendment Act added which all terms to the constitution or to the preamble? Anyone can tell me? Chandra Prasad, you can join the official Telegram channel of Tathastu ICS. There you will get access to all the PDF that we discuss in the DNA session. It's being uploaded every day in that channel, both the Hindi as well as the English DNA. Yes, only Monday to Saturday, not the Sunday. Very good. Very good, Ekta. It's socialist, it's secular, and it's integrity. Right? These 3 words are added by 42nd Constitutional Amendment Act 1976. अब सुप्रीम कोर्ट ने कहा कि माना 1976 में इन वर्ड्स को ऐड किया गया, but that does not mean कि ये वर्ड्स पहले से नहीं थे, बट हमारे कॉन्स्टिट्यूशन की कोर फिलॉसफी इन वर्ड्स के सराउंडेड ही थी, राइट. वी हैड दो सोशलिस्ट मॉडल्स एज वेल. फॉर एग्जाम्पल, वी हैव मनरेगा स्कीम, right? We discussed all of this yesterday. We have National Food Security Act as well. We have right to education as well. So all of these shows our commitment towards the socialism as well as secularism. Secularism, हमारी सरकार ऐसा नहीं है कि हमारे ऊपर टैक्स लगा रही है in order to promote or fund one of the religions. It is acting neutral with all the religions, and state has no official religion as well. Okay, then comes the next. This reaffirmed both concepts are consistent with the core vision of the constitution. Now it is saying that Dattaraya Hosabale is asking to remove the terms to challenge the Ambedkar's vision, as well as the Supreme Court. The Vice President of India, Jagdeep Dhankar, is saying that 42nd Amendment, which is also known as mini constitution as a sacrilege to the spirit of the Sanatan, as a spirit of the Sanatan. It argues that this is not academic critic, but a calculated political campaign to delegitimize modern pluralist and secular Indian Republic. अब यहाँ पे बात आती है हमारे सेक्युलरिज्म फीचर्स की, जो अभी से नहीं बल्कि बहुत पहले से ये चीज हमारे इंडिया में एग्जिस्ट कर रही है. सो महात्मा गांधी सेड कि स्टेट shall not support any official religion, rather it should remain be neutral in all the religious matters. Then Ambedkar has said कि स्टेट का कोई भी रिलीजन स्टेट का नहीं होना चाहिए, rather it should respect all the religion, and that is why we have article 25 to 28, that is all the right to religion or the religious practices which everyone can perform, the freedom of religion. Okay, then Sardar Patel has said that there should not be any communal provisions, right? He was against the separate electorates as well. He is also known as the Iron Man of India. Then comes Begum Azad Rasool, who was the only women member in the Constituent Assembly. Sorry, only women Muslim member in the Constituent. Only women Muslim member in the Constituent Assembly. And then last, Govind Vallabh Pant, he warned against the dangers of a theocratic Hindu state. He said, अगर हिंदू स्टेट को एक हिंदू राष्ट्र बना दिया जाए तो उसकी जो सिविलाइजेशनल लेगेसी है, टॉलरेंस की, प्लूरलिज्म की, जहां बहुत सारे कल्चर, बहुत सारे रिचुअल्स, बहुत सारे धर्म एक साथ एक छत के नीचे रहकर खान पान करते हैं, बहुत ही आसानी से मिलजुल कर रहते हैं, that would be in danger. So that would be the main problem. Okay, so here Govind Vallabh Pant said the dangers of the theocratic Hindu state. Okay, then we will move to the next, that is secularism as a basic structure. So as per the Keswananda Bharati judgment, now this is the case versus state of Kerala in the year 1973. There they said that basic structure of the constitution cannot be constitutionally amended, and the inclusion of the word secular in the 1976, it has reaffirmed the principle already, which is foundational to the Indian democracy, and it has repeatedly said that secularism is a part of the basic structure. Now you all, I'm sure you all must be having an idea about the doctrine of the basic structure, कि जो भी हमारे basic features हैं, foundational tenets हैं, then three-minute UPSC, please. है ना? Let's just focus here, बच्चे. Let's focus here. Then comes the socialism. Then socialism in the Indian context refer to welfare state principles, economic justice, as well as reduction of inequality. Now this is mentioned in directive principles of state policy. Then also the article 38, 39, 41, 42, 43, it also embody the socialist vision. Today I am not discussing all these articles because I have discussed all of these yesterday as well. Then Ambedkar supported these principles as a key to social transformation, to economic transformation, and it has also clarified inclusive growth, eradication of caste exploitation, landlessness, poverty, and there is no other foreign ideology. But if these words are being removed from the Constitution of India, it will be a threat. Threat to whom? Threat to communalism as well as the majoritarianism which is prevalent in the country. So it is saying कि जो mainstream governance है, that would be religious symbolism in state functions, and it is saying Ram with Rashtra, with Ram temple consecration, it contradicts the constitutional mandate and could threaten the minority rights. Minority rights are being given in Article 29 and Article 30, which says what? Cultural and educational rights of minorities, and they have a right to protect their language. They have a right to protect their script. They also have a right to protect their culture as well as pluralism and democratic institutions. So all these points are important from this perspective. Okay. Then comes the next language, script, culture. We have discussed Article 29 to 30, the cultural educational right of the minorities as well. Then comes a PYQ for you. Now quickly tell me the answer here. What do you mean by the term secular? This was not asked in the year 2017. Sorry, remove this. It's not in the year 2017. Very good. Rishi, Hina, Yogita, Mansa, Dheeraj, everyone is giving the correct answer. See, this was a PYQ only, but it's around of 1990s. Okay, it's that old PYQ when you were not even born. So freedom of religion and worship to all citizens. Even I wasn't born that time. Then comes the next question asked in, I'm really sorry for this, but these questions are not asked in these years, right? It's not 2021. It's a PYQ only, but tell me the answer here. Shraboni, bache, you can text just once. You can give your comment once. I will see it, right? Do not spam. Even if you are commenting 5-6 times, not a good thing. आप बस एक बार comment करो, I'm there. I can see all the names on my screen. Okay, I can see all the names. Izar, Banti, Kathiravan, Ekta, Shraboni, Mandal on the screen. I can see that. Good, Khan Bhai, Rishi, Dheeraj, Anish, Roshni, Sonali. Everyone good? A, very good. Yogita, Deepika, absolutely correct. So the correct answer here is we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and do hereby adopt, enact and give to ourselves this constitution. So this is the question. Then comes 2013 question, that is regarding economic justice. Now solve this question quickly. Good. The correct answer here is B. That is the preamble as well as the DPSP, Directive Principles of State Policy, and is related to the economic justice. Then comes under prelim Sarthi, we have one important Nipah virus which is resurfacing in the state of Kerala. So what it is a zoonotic virus, which means it can be Nipah virus, again in news, in the state of Kerala. So it is a zoonotic virus, which means that it can be transmitted from animals to the human beings. Okay, then it first appeared in Malaysia, the Malaysian pig farmers, in the year 1999, and then in 2001 it was caught in the country of Bangladesh and at the same time the eastern part of India, because both of them are sharing the borders. Our eastern states, northeastern states are sharing the borders with Bangladesh as well. This is the newspaper clipping. Nipah virus resurfaces in Kerala, 2 cases reported. Then in India, the first case was outbreak in Siliguri, that is a city in the West Bengal, in the year 2001. Okay. Now solve this question quickly, everyone. It's not a PYQ, it's just a practice question. Yes, Khan bhai, absolutely right. It's in on and off in news. Quickly solve this question. Very good. It's a zoonotic virus. That means it can be transmitted from animals to humans. First statement is right. Second statement is wrong. It's in Malaysia. Okay, it's in Malaysia. Then third, eastern parts of the country, that is West Bengal, Siliguri. So the correct answer is B. That is 1 and 3. Good. Mansa, Yogita, Kathiravan, Rishi, Sonali, Hina, Ekta, all of you have given the correct answer. With this, I conclude today's daily news analysis session. I hope you have understood all the news. You have solved PYQs as well. They give you a strong foundation, strong understanding of how to solve the questions. Try to solve as many questions as you can, both prelims and mains. With this, I conclude. Jai Hind, Jai Bharat. Thank you.